It is not a blatant act like taking one's own life. The court made clear that it would not be considering the issue of euthanasia, while quoting from Airedale National Health Service Trust, directives. Fland, 1992, multiple times and made a distinction between the right to die, which is unnatural, and the right to die with dignity, which is natural. Also, it was upheld that sections 306 and 309 of the Indian Penal Code, 1860, are constitutional. Despite this commendable judgment, the issue concerning the legality of euthanasia did not come to an end. In the year 2011, the issue regarding the legality of euthanasia was raised in the case of Aruna Ramachandra Shanbhag Union of India and others, 2011. The court concluded that Jian Kaur permitted the early death of a person who was suffering from a terminal disease or was in a lifelong vegetative condition. Withholding treatments with the purpose of swiftly bringing about the patient's death was described by the court as passive euthanasia. It was decided that passive euthanasia was acceptable, provided doctors removed the patient's life support in accordance with informed medical advice. The court becomes the ultimate decision maker of what is best for the patient when the parens patriae principle is invoked. Parens patriae is the Latin phrase for parent of the nation. The principle states that the court has the authority to intervene and act as a guardian. Article 226 gave the High Courts the power to exercise this authority. Moreover, the court stated in the case of Jian Kaur Fursert, the state of Punjab, 1996, that euthanasia could be made legitimate only by the introduction of the concerned legislation. Analysis of the precedents by majority opinion holders. First, contrary to what was held in the case of Aruna Shanbhag, Chief Justice Misra claims that Jian Kaur's judgment merely made reference to a portion of Airedale and that Jian Kaur's reasoning did not include the Airedale case. Second, Jian Kaur's decision did not condemn the idea of euthanasia. In fact, it suggested that it might fall under the category of the right to a dignified life. It also made a distinction between intentionally taking one's own life and taking one's own life by refusing medical care. Second, Jian Kaur's judgment did not suggest that euthanasia could be legalized. Aruna Shanbhag's bench misunderstood Jian Kaur's judgment. After that, Chief Justice Misra talks about the current situation to start. He defines euthanasia. Generally, there are two types. Passive euthanasia, when there is no overt act of administering medications or substances that will end one's life, and active euthanasia, where there is an overt act done to end the life of the individual. The case of Aruna Shanbhag permitted passive euthanasia. However, she set restrictions and prerequisites. There is a ban on active euthanasia. Euthanasia may also be non-voluntary or voluntary, depending on the decision-making capacity of the patient. There is also physician-assisted euthanasia, which is largely based on the doctor's recommendations. The British Columbia Attorney General, Versi, Rodriguez, 1993, and Vaco Vor, Quill, 1997 decisions said that the intention and cause of death are what separate active from passive euthanasia. Chief Justice Misra supported this rationale. The majority view on the right to deny treatment or medication. Expressing the view of the majority, Justice Deepak Misra acknowledges the right of individuals, above the age of 18 years, to make their own choices. Individuals even have the freedom to choose whether to opt for medical treatment or not. He stated that an individual's freedom to make choices and their self-determination constitute the fundamentals of life. Therefore, the choice to forego medical care belongs to every adult who is of sound mind. Besides this, the decision may be void if the individual was not legally qualified to make a decision, if it was made under pressure, if the terms were unclear or confusing, or if it was based on false information. In contrast to euthanasia, physician-assisted suicide, and suicide, Chief Justice Misra places the right to make choices on a higher pedestal. He makes it clear that refusing medical assistance is neither euthanasia nor suicide, as they are both self-initiated positive actions taken with the express purpose of causing one's own death. The majority opinion also referred to the principle of necessity. This principle refers to the cases of emergency, when taking consent of the patient is not possible. In these situations, the doctor is required to act in the best interest of the patient. Given the inability to interact with the patient, such a measure would be essential. It would have to be one that a prudent person would adopt in the patient's best interests. The opinion of the majority was supplemented by the following cases: Schlendorf v. Society of New York Hospital, 1914. New York Court of Appeal 2 FVR, 1983. Supreme Court of